Welcome, everyone. Thanks for joining us today in the Talking Animals, Law and Philosophy series. Some more people in the waiting room. There we are. It's great to see so many of you here. My name is Raphael Fazell. I'm the Executive Director of the Cambridge Centre for Animal Rights Law. I see some familiar faces in the participants list, but also some new people. So just a few words on the format of the Talking Animals series for those of you who are here for the first time. We will start with a presentation by our speaker that will last for about 30 minutes or so, and we'll then have another maybe 45 minutes for discussion. You are all warmly invited to participate in the discussion, and we'll end at about 6:30 p.m. UK time. For those of you who would like to participate, please could I ask you to use the raise hand function. You will find that under the little reactions, the smiley button on the bottom of your Zoom app, and then you can chip in if you have any questions or comments for our speaker. If you prefer, you can also use the chat function that's available too, so you can just type in your comments there if you prefer. All that will take place in the discussion part of this session. Until that point, I will be muting all the microphones. Okay, very good. As you may have heard before, we are also recording this presentation. I will, however, stop the recording before the conversation starts, so you can feel free to come in with any comments. You don't have to feel inhibited in any way. Very good. Okay, with this out of the way, it is now my pleasure to introduce our speaker tonight. We are particularly pleased to have with us today Katharina Braun, who, as some of you may know, is a research visitor at the Cambridge Centre for Animal Rights Law, and she's also a PhD candidate in law at the Free University in Berlin, where she's currently writing up her PhD thesis on animals, free speech and democracy, legal responses to undercover footage, which sounds really fascinating. Katharina completed her first Staatsexamen at Free University of Berlin, and she also obtained an LLM from the University of Connecticut School of Law. In 2021, Katharina was awarded first place in the center's essay competition. The essay is actually available on our website if you want to read it. It's a fantastic piece. During her visit here at the center, Katharina is examining whether the concept of consent or related concepts can be employed to distinguish between legitimate and illegitimate human-animal interactions. And today, she will be exploring some of these findings from her research with us in her presentation entitled Examining Consent-Based Justifications for Human-Animal Interactions. Katharina, over to you. Thanks a lot for being with us.
Yeah, hello, everyone. Thank you, Raphael, for this kind introduction, and thank you for having me here today and as research visitor at the center. And yeah, welcome, everyone. It's really nice to see some familiar names and faces on the screen. Just give me a moment while I share my screen. So as Raphael already mentioned, the title of my talk today is Examining Consent-Based Justifications for Human-Animal Interactions. Before I begin, let me say a few words about the background and aim of this project. What I present here today is part of my ongoing research project at the Cambridge Centre for Animal Rights Law. As this is an ongoing research project, I'm really keen to get your feedback and comments later in the discussion. So what I want to do in this project is to really move beyond the legal status of animals and focus on human-animal interactions and relationships instead. I think in a future where animal rights are respected, we will need new legal concepts to govern our interactions and relationships with them. So those of you who live with a companion animal might already have some ideas in mind of where I'm getting at here. So for example, you can consider what is if your companion animal resists an important medical procedure? Or what if she enjoys an activity that you don't approve of because it is quite dangerous for her, like roaming around busy streets. Or this is maybe a less likely example in everyday life, but what if your animal enjoys enthusiasm about some activities that are not really beneficial for her, but could be beneficial for humans to observe? Like if your animal would be participating in research. In all of these examples, we have to ask ourselves, how does the expressed subjective preference of an animal feature in our assessment of whether it is permissible to engage her in a certain activity or not? There is some brilliant recent literature about concepts related to consent in the context of animal labor and animals used for research. What I want to do today is to figure out how this literature relates to animal rights law. And when I speak about animal rights law today, I mean the lege ferenda, an animal rights law of the future, where we hopefully respect animal rights. I want to ask, which legal concepts should be employed to navigate our interactions with animals in the future? And more specifically, I want to ask whether there is room for a consent-related concept in doing so. So briefly, here are the steps that I want to take today. First, I will ask whether animals can consent. In a next step, I will look at some concepts that I will describe as consent-related concepts today, such as the Assent Dissent model that has been proposed by Richard Healey and Angie Pepper, and embodied consent that was developed by Charlotte Blattner. I will then speak about the risks of applying consent-related concepts to animals and propose another possible way forward, and then share some of my conclusions or main takeaway points. So let's begin with the question whether animals can consent. In interactions between humans, it is widely accepted that consent can make a difference between a violation of a fundamental right, such as bodily integrity, and a routine medical procedure. Consider the example of donating blood. If I consent to donating blood, having my blood taken for this purpose is not a violation of my rights. If I do not consent, taking my blood for the purpose of donating it would clearly be a violation of my rights. But consent is also relevant in the most mundane everyday life decisions, if I make a contract to purchase a product, for example. So now it is widely accepted that animals cannot consent in the same way as humans. Historically, there might be multiple reasons for this. So, for example, in the Bible, it is written that God conferred dominion over animals to men. But the view that animals cannot consent is also the most prevalent view in animal rights scholarship. So some authors point to the problem of shared language, for example. Because humans and animals do not share the same language, it might be difficult for animals to consent. The lack of shared language could rule out the possibility of consent. I don't agree with this view necessarily, because it implies that if animals could consent, if animals could speak the same language as us, their consent would be possible, and I'm not so sure about that. Also, many animals possess language and we fail to understand it. So both speaks against looking at the lack of shared language as making consent impossible. Others might say that the problem is rather with informed consent, because most animals do not understand the information relevant to the decisions at stake. This might be true with regard to some decisions, for example, when it comes to medical decisions. But I think in many situations of everyday life, animals actually do understand necessary information. For example, a dog will understand what it entails to go for a walk in the rain. Rather, I think that the problem is with consent itself. As Richard Healey and Angie Pepper have said, animals likely lack the capacity to form complex intentions which are necessary to waive a right. And that is what consent requires. To give consent, animals would have a concept of what it means to have a right and to waive it, so that they can form the necessary complex intentions regarding these concepts. But now, what do we make of this? If animals cannot consent, does this mean that all interactions with animals are permissible as long as they're not getting hurt? Maybe as long as their welfare is respected? Or quite the opposite, does it mean that we have to end all human-animal interactions, including those with companion animals? That would correspond to the so-called abolitionist position. So as you can see, this problem corresponds to a long-standing debate in animal rights law between welfarists and abolitionists. I don't think that either of these extreme positions is very desirable. Instead, we need to create some space in between. And here the Assent Dissent model and embodied consent are very promising. So if I understand correctly, both of these proposals are based on the assumption that animals have an interest in self-determination. And assent or embodied consent, although not identical with consent, could have the same consequences as consent. If I understand correctly what authors have so far argued, the idea is that assent or embodied consent would indicate that an animal is disposed towards a certain activity, and therefore engaging her in that activity would not violate her rights. So what I want to do today is to carve up some conceptual space for these proposals in animal rights law. Let's first look at the assent and dissent model as it was developed by Angie Pepper and Richard Healey. Assent refers here to the willful affirmation of an act, which can also be communicated non-linguistically. The authors were predominantly concerned with what they call one-off interactions between humans and animals. So to give an example, you can think of a dog who is waiting at the gate with a toy, and this dog could be considered to assent to go for a walk. But for assent to be morally transformative, some requirements must be met. An animal must assent voluntarily. That means she must have the opportunity to dissent, and she must assent with sufficient understanding, which requires that she has the relevant information to make the decision. Angie Pepper and Richard Healey have also said that expressed preferences of animals can sometimes be overruled if an animal does not understand the relevant information. This would be the case, for example, when it comes to getting vaccinated against a dangerous virus. Assent-dissent models have also been discussed in the context of research involving animals. For example, here in the Talking Animals series, we had a great talk a couple of weeks ago by Angela Martin on animals in research. But today I don't want to go into detail about these proposals, because I'm not entirely sure if the assent-dissent model that authors in this context propose is identical with the one that Richard Healey and Angie Pepper had in mind. Another recent proposal is embodied consent. This was advanced by Charlotte Blattner. The idea is that in the context of animal labor, embodied consent could safeguard animals' rights to freely choose their work. So it could help animals to maximally secure their interests on their own terms and under their own conditions. Embodied consent differs from informed consent, which would be the gold standard in the human case. For example, the mode of communication here would not be based on legalistic forms of communication, such as giving a signature. But embodied consent also differs from assent. Charlotte Blattner has criticized that an assent model typically requires a guardian, and a guardian tends to have over-paternalistic power over animals. So a guardian can overrule the subjective will of an animal, and the risk is that she does so if an animal's expressed preferences are not coherent with the guardian's assessment. Instead of guardianship, the embodied consent model would rely on public discussion and standard setting. And if I understand correctly, embodied consent could also be a more realistic standard for humans when it comes to decisions of everyday life. So as I've already said, I think these proposals are very promising, especially in the micro contexts and individual interactions that they primarily seek to address, such as our interactions with companion animals and with working animals. But again, the question I want to ask today is slightly different, because I want to examine whether they could inform the future of animal rights law. And to do that, I think we need to take a very close look at the risks of applying these consent-related concepts to animals. The first risk is what I will call the human interlocutor. Animal assent, dissent, and also embodied consent also pays to make room for animals' subjective will rather than that of a guardian. But humans would still play a really crucial role. So interpreting animals' expressions and deciding whether their subjective will should be decisive in a given case will always be up to humans. And I think this could potentially be a problem, because humans interpreting animals' expressions are likely to be wrong. This is not necessarily due to bad intentions. Even with animals who we've lived with for a long time and who we like very much, we might not always be able to really tell what they want. But even greater is the risk when we think about animals that have been farmed for a long time. So our understanding of what farmed animals want and what their nature is might be distorted by the tradition of animal farming. But I think that the problem of the human interlocutor can be mitigated. As Charlotte Blattner has proposed, groups rather than individual humans could be responsible for determining animals' best interests and interpreting their expressions. And humans also just need to relearn how to listen to animals. This has been proposed frequently in the literature. But perhaps most importantly, we need to learn to respect animals' dissent. And this includes, in the words of Catherine McKinnon, to respect when animals vote with their feet by running away. But even if the problem can be mitigated, I just wanted to flag this, because I think we have to ask ourselves, if assent or embodied consent is to have the same consequences as consent, how much misinterpretation can we risk then? Another problem or risk is that with assent or embodied consent, we might be glossing over some persisting power imbalances between humans and animals. think of selective breeding, for example. We have specifically designed animals to display certain features that make them more or less disposed towards certain activities. Of course, this is most prominent in the area of farmed animals, but you can also think of dogs like the Doberman or German Shepherd have been used as guard dogs for a long time. So I think even if we were to discontinue selective breeding today, its existence in the past will still affect individuals in the future. And I think we have to critically question whether we should attach the consequences of consent to expressions of preferences that we have shaped so drastically over generations of animals. A related but slightly different problem is that of adaptive preferences. I'm taking a definition of Martha Nussbaum as a starting point here. Adaptive preferences means that individuals adjust their preferences to the options achievable to them, or simply to the way of life they know, without being aware or in control of this process. So this means that individuals who have been subjected to unjust treatment for a long time sometimes do not recognize this treatment as unjust. Now, it is widely accepted in the human case and in our legal systems that adaptive preferences do not prevent consent. But I think that there are some important differences between adaptive preferences in the case of humans and animals. Even if subjective preferences are shaped, for example, by prior injustices, humans who are capable of consent will usually have the capacity to reflect upon the options they're presented with and to measure those options against what they believe is due to them as a matter of justice. Even if at that point they don't think that they are owed these options as a matter of justice, they have the capacity to do so. And I think this really makes a difference because most animals likely do not have the capacity to do the same, to think of themselves as having rights and as being owed certain things as a matter of justice. This does not mean that animals shouldn't have rights, quite the opposite. It means that we have to protect them even more. We have to understand that we can present animals with different choices and options for their lives, but those choices will be pre-chosen by us. So animals will rarely be able to reject a certain option on the basis that they know that they would be owed more. So these are just some possible risks and problems that I wanted to point out. And I'm sure that many of you will have some responses to them in the discussion later. I still want to consider some possible responses here. Many of you will argue that the risks I just pointed out are independent from assent or embodied consent. Rather, they're always present in human-animal interactions. And I would absolutely agree with this. But I think that these risks are more dangerous when we think in terms of consent-related approaches, because there is a risk of obscuring them if certain decisions pertaining to animals are portrayed as the animal's own. But even then, you might say that assent or embodied consent are necessary despite all these risks, because animals have an interest in self-determination that they can reflect. So this is a difficult topic, and different positions exist in the literature. So Alistair Cochrane, for example, argued that animals likely don't have an interest in self-determination in the way that it would be relevant for assent or embodied consent here. For the purpose of this argument, I will assume that animals have an interest in self-determination. But I think that even if animals have this interest, it is in most cases limited compared to that of humans, because most animals have less capacity of long-term planning and self-reflection. And Angie Pepper and Richard Healey have also pointed this out in their contribution on the subject. But I would add that animals' interest in self-determination, or rather the extent to which they can exercise it, is always restricted by the fact that humans will determine the structures and the contexts in which we interact with animals, including the law that governs our interactions with them. So this means two things. First, a certain level of paternalism is always present in human-animal relationships. But it also means that this paternalism is less problematic, and certainly less problematic than in the human case, because animals' interest in self-determination is less weighty. But still, all of the risks that I pointed out can be addressed and mitigated, and self-determination can have a place if the application of assent and embodied consent is limited to certain contexts. So if we look at this through a distinctively legal lens, then I think the problem of, limiting down the application of these contexts could give rise to a different problem. And that has to do with generality. Generality is a formal requirement of the rule of law. It means that legal norms must be universalizable. But generality, if we think about it, is also an important part of legal reasoning more generally. For example, when we think about precedent, especially in the common law contexts. So basically, it means that certain individuals cannot be targeted by or excluded from a given norm just because we find the outcome undesirable in these cases. And what does this mean for animals now? I'm worried that if we apply assent, dissent, or embodied consent to interactions with, for example, companion animals, then why should we not also apply it to farmed animals or animals used for research? Just to be clear, I don't think that this problem arises so much with the existing proposals as they have been made. These proposals really safeguard animal rights because they come with limits and caveats. Only without these limits and caveats, there would be a risk of legitimizing animal use that should be critically questioned. For example, perhaps some research involving animals. But with these limits and caveats, I'm not sure if the proposals are yet sufficiently general to become a legal concept. So against this backdrop, I would propose a different possible way forward. And to many of you, this will actually seem like a step backwards. I would suggest to return to the idea of a guardianship model while taking animals' interests and subjective preferences into account. I think we could take legal reality as a starting point and look at guardians who can consent for children. I don't think that the analogy between animals and children is conceptually convincing, because especially fully grown animals are perfectly capable of navigating their lives and interactions with other members of their own species and other species as well. in a way that toddlers, for example, are clearly not. Although this analogy is not conceptually convincing, I think that guardianship might be the most adequate legal tool that we have at our disposal. So the idea would be that guardian consent could be something like the norm, with safeguards in place to consider that animal assent and dissent are respected in the decision-making process. This could also involve an element of public discussion and standard setting, as Charlotte Blattner proposed, for example, when determining what is in the best interest of animals. So in practice, my proposal would not be too different from the existing proposals, except I would insist that guardians' decisions must be based on animals' best interests, rather than on assent or embodied consent. I think this is necessary to temper the risks which I outlined. So although that these proposals could be similar in practice, I don't think that a guardianship model based on animals' best interests could justify research that deprives animals, for example, of a more joyful life, or animal work that involves some serious risks. For these interactions with animals, other justifications might be possible. For example, when animals have an interest in the outcome of research. So here are my conclusions or main takeaway points. I think the space for consent-related concept in animal rights law is rather limited. We can accommodate insights from the assent-dissent model and embodied consent while tempering the risks. But this requires that we acknowledge that humans will always determine the contexts in which their interactions with animals take place, and that animals will rarely be able to hold us accountable if we fail to do them justice. This means that they need a particularly strong legal protection of their interests. A certain level of paternalism might be unavoidable and less harmful than we think, given the limited capacity for self-determination that animals have. If we have a guardianship model, then guardians must decide based on animals' best interests while taking subjective preferences into account. But still, the assent-dissent model or embodied consent could play a role in some narrowly defined contexts, but these would be the exception from the rule. Here are the sources that I quoted on the slides. Thank you very much for your attention, and I look forward to discussing these things further with you now.